What's good, Professor Wallacord? Back again. Chapter 17, Biz Law. I'll give you main points here of this chapter as well as the summary itself in general. So here's what I picked up from Chapter 17. So this was about the third party rights. So it was all about assignments, delegations, effects of the assignments, rights that can't be assigned, decision and remedy, duties that cannot be delegated, effective delegation, types of intended beneficiaries, and so on and so forth. So we'll start at the top here on assignments and delegations. So in a bilateral contract, the two parties have corresponding rights and duties. One party has a right to require the other to perform some task, and while the other has the duty to perform the task itself. So assignment is a transfer of contractual rights to a third party, whereas delegation is the transfer of contractual duties to a third party. And I'll get more into the examples of a delegation in a sec, but we hear about it a lot, especially through school and our group work. So the effect of an assignment is when the party assigning to the rights to a third party is known as the assigner, and the party receiving the rights is the assignee. So in other traditional terms used to describe the parties in assignment relationships are the obligee. So that's when a person to whom an obligation is owed, and the obliger to whom an obligated to perform the duty itself. So the rights that can't be assigned, all rights can be assigned in general, but there are some exceptions, and those exceptions include the assignment prohibited by statute, when the contract is personal, the assignment significantly changes the risk of duties of the obliger, and when the contract prohibits the assignment. So moving on with the decision and remedy, this is, when a state intermediate appellate court affirmed the lower court's order. So the contract, let's say in one of the case studies between Cipriani and Ali, I believe, was voided because Cipriani could not assign his rights under the lease without Bass-Feinberg's another name situation without consent. So you need consent for everything. That's when everything's consensual. You need that for many things in legal life itself too. So for the notice of assignment, it is once a valid assignment of rights has been made, the assignee should notify the obliger of the assignment. So giving notice is not legally necessary to establish the validity of an assignment, but when an assignment is effective immediately, whether or not is given, the two major problems arise. So when notice of the assignment is not given to the obliger, those two problems will arise. So that will lead to some priority issues. And so you ask yourself, what's the most important thing to do in these circumstances? So duties that cannot be delegated is 1, when special trust has been placed in the obliger, or when performance depends on the personal skill of talents of the obliger. 2, when performance of a third party will vary materially from the expected of an obligee. And 3, when the contract expressly prohibits delegation. So effects of delegation, there are issues. If a delegation of duties is enforceable, the obligee must accept performance from the delegate, and the obligee can legally refuse performance from the delegate only if the duty is one that cannot be delegated. So when we talk about delegation, let's say in schoolwork, an example is you're doing a group project and you have to delegate. Let's say you get 3 different points, and this point of information is for me, the second one is for a person in my group, and the third one is another person in my group. So you got to delegate the work, and it all comes together at the end, and that is when you get the grade for the assignment, or you work together doing 33.3% of the assignment per se, and that's how you get your end result. So that's when someone has the duty to pick up and deliver goods to someone else's property. The duty is then delegated to someone else, as I said, like a group project, and so they work together to get the goods to the person's property, or for the end grade of the assignment, is for my example. So another exception of the doctrine of privity of contract arises when the contract is intended to benefit a third party. So the original parties have to agree upon it before moving on. So let's say the two types of intended beneficiaries is when one, creditor beneficiary, which benefits from a contract in which one party promises another party to pay debt that the promisee owes to a third party, and two, the donee, I believe is how you say it, beneficiary, which is when a contract is made for the express purpose of giving a gift to a third party. The third party can sue the promiser directly to enforce the promise. So a lot of what I got from this chapter, I have one more note to make, is that um, just working together is the biggest thing, and getting in groups, or whether it's for those groups or for different assignments, that's the biggest thing. So which one or more of the following factors strongly indicates that the third party is an intended beneficiary to a contract? One, performance is rendered directly to a third party. Two, the third party has the right to control the details of performance. And three, the third party is expressly designated as a beneficiary in the contract. So it kind of goes with many things in life, through schoolwork, and we're just going to have to deal with it a lot. You got to be able to delegate work. You have to understand the situations of the third party. And that's just business. That's business law. And I did like this chapter. I did learn a good amount from it. I'm a little over the time, and that's what I have for you.